So, guys, for those of you that aren't familiar with the parameters and the legalities behind what it takes to obtain a search warrant, I wanted to let Mr. Dan E. Chambers, a lawyer from Irvine, California, give you a little bit of an explanation as to what law enforcement has to go through in order to obtain a search warrant and the parameters in regards to that. So pay attention, and I'll see you on the other side of the video.
Hi, this is Dan Chambers of the Chambers Law Firm. Chambers Law Firm is a full-service criminal defense firm that represents individuals and businesses for crimes that are prosecuted in both state and federal court. Today we're going to begin to tackle and scratch the surface, really, of the Fourth Amendment search and seizure laws and when a warrant is required by the police to conduct a search or make a seizure of a person or evidence. It's a huge body of law that's been developing for over 100 years, and it's quite a topic to tackle. So we're going to take it in bite-sized pieces. Today we're going to talk about the general requirements for a warrant. There's a lot of misconceptions out there that have been caused by a lot of different things, the media, word of mouth, bad advice, frankly, about when a warrant's really required. So we're going to look at the constitutional requirements and what specifically is required so that we can define when the police need a warrant to conduct a search. The Fourth Amendment of the United States Constitution provides that people are entitled to protection from what are called unreasonable searches and seizures, and that no search warrant can be issued unless it's signed by a magistrate under oath, supported by probable cause, and that it specifically describes the place to be searched or the items or persons to be seized. Let me try to break that down a little bit. So basically, the Fourth Amendment protects you from an unreasonable search and seizure. Well, that's what triggers all of the case law and all of the litigation over what's unreasonable and what's not. The second portion of the Fourth Amendment requires that any search warrant that's issued has to be reviewed by a judge or a magistrate, and it has to be signed under oath by the police officer or the detective that's seeking the warrant. An oath simply means that they're signing it under the penalty of perjury, that it's got truthful information in it. And if it's supported by probable cause, the magistrate will issue the search warrant. So, it all sounds good in theory, right? We've got an unreasonable search and seizure requirement, and search warrants have to be signed by a judge and issued on probable cause. But it's not that simple. To reflect the realities of how police officers have to do their job every day and deal with situations that they encounter in the field, it may not always be practical or necessary to obtain a search warrant. So the courts have now developed a large body of law to describe situations that they call exceptions to the warrant requirement. Those are basically situations that a police officer will encounter in the field where it's impractical to get a warrant, or frankly, because of the circumstances, it's not required to get a warrant. That large body of case law has developed on the issue of what is and what is not an unreasonable search and seizure under the Fourth Amendment. In my next video, we'll start tackling some of the major exceptions to the warrant requirement, and they're lengthy and complex. If you have any questions about this material, please feel free to contact the Chambers Law Firm at the information provided at the end of this video. Thank you very much.
So guys, there you have it. I hope that that's kind of helpful in regards to, what the search was on Potomac at Wanda and Phillip's house. Sorry, I've got a lot of cases jumbling around in my head right now, guys. But yeah, that's the same for all states. You have to have the probable cause and all the other mitigating factors as well. So. There's a lot that goes into a search warrant, although it's not used to try to shed a criminal light. It often is, more oftentimes than not, it's involved in criminal cases. So it's a useful investigative legal tool. And that you just saw was the official parameters for a law enforcement search and seizure. Thanks, guys. If you have any questions, comments, or concerns, leave it in the box below. Remember, like, share, and subscribe. And also, The absence of evidence is not the evidence of absence. Thanks, guys. God bless.